You got a referral notice from USCIS. Look, I'm not going to sugarcoat it. The asylum officer concluded that you're not eligible for asylum. That's a real negative decision and it hurts. But here's something you need to understand before you do anything else. A referral is not the same as a formal denial. And that distinction is not just a legal technicality, it has real consequences for your case and your path forward. I'm going to explain what the referral notice from USCIS means for your asylum case, why the difference between a referral notice and a final denial matters, and what your options look like from here. And we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government. I adjudicated thousands of immigration applications during the 11 years that I worked for the government's two main agencies for asylum and refugee matters. But now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. Let me know in the comments, by the way, if you've received a referral notice from USCIS. Tell me where you are in the process right now, like whether you're waiting for your first court hearing, or maybe you've already had it and you're waiting for your second one. Okay. So let's start with the most important thing. What actually is a referral notice and what is it not? So when you went through the affirmative asylum process, you filed your Form I-589 application with USCIS. You waited sometimes months, sometimes years for your interview date, and then you sat down with an asylum officer. You answered their questions. You told your story. And at the end of that process, later, instead of receiving a grant of asylum, well, you got a referral notice. And along with it came something called Form I-862, which is a notice to appear. Now, those two documents, they arrive together in the same mailing, and together they tell you that, well, your case has been transferred or referred, if you will, to immigration court. This means that the government has formally placed you in removal proceedings. The US government, now it's actively trying to deport you. In that moment when you see this decision, well, it's genuinely disappointing. After everything that you went through, the waiting, the anxiety, the grueling asylum interview itself, that is not the outcome that you were hoping for. And if you had an asylum lawyer at the affirmative asylum stage who you feel maybe let you down, or maybe you went through it alone and you wish you had done some things differently, well, I gotta tell you, those feelings are completely normal and understandable. A lot of people are in that situation right now. Here's the key distinction that you need to understand. For most affirmative asylum applicants, and by the way, we're talking here usually about people who came on a visa and then they overstayed. Well, the asylum officer does not have the legal authority to issue a formal denial. You see, what they can do is refer your case, and that referral is not a final denial. It's like a transfer to a completely different decision maker, an immigration judge who has full independent authority to look at your case fresh and either issue a deportation order or, if you present a strong enough case, to grant you asylum. So think of it like this. The asylum officer concluded they could not approve your case. And yeah, it's true that they did conclude that, well, you don't qualify for asylum, but that decision is not binding. It's not the same as a judge concluding that you don't qualify. The immigration judge who will hear your case, well, they get to evaluate your claim again, your testimony, your evidence, your full story, and make their own completely independent decision in the case. They're not required to follow what the asylum officer concluded, okay? So that's the good news, right? The officer's reluctance to approve your case doesn't follow you into that courtroom like a verdict already stamped on your file. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. Okay, so let's talk about what defensive asylum actually means, because this term matters. You're going to be hearing it a lot. When your case was in the affirmative process, you were an applicant requesting asylum from USCIS. Now that your case has been referred to immigration court, you're a respondent in removal proceedings, and asylum becomes what's called defensive asylum. Defensive in this context just means that you're seeking asylum as a defense against removal. So instead of affirmatively asking USCIS for protection, well, you're now defending your right to stay in the United States before an immigration judge. Now, the underlying legal standard for asylum is exactly the same. The same legal definition applies in both contexts, same burden of proof. What has changed completely is the forum, the process, the stakes, and who's sitting across from you. You see, in the affirmative asylum process, there was no one arguing against you. But in immigration court, there is a government attorney, an ICE attorney, a prosecutor, whose job is specifically to argue that you should be deported. And the forum matters enormously. The immigration judge conducts a completely independent hearing, okay? They're going to review your asylum application. And by the way, you don't have to refile it. Your existing application carries over. But they hear your testimony, they evaluate your evidence, they hear from both sides, and then they make their own decision. This is not an appeal. The judge is not like reviewing the asylum officer's conclusion. Rather, the judge is hearing your asylum claim from scratch, okay? Something else worth knowing that most people don't realize, the immigration judge can actually grant two forms of protection that the asylum officer cannot: withholding of removal and protection under the Convention Against Torture. These can only be granted by an immigration judge, never by the asylum office. Now, in some situations, the immigration court actually has broader authority to protect you than USCIS ever did. So when your case was referred, you didn't lose access to protection. In certain ways, you gained access to more forms of it. So this is your case, it's alive, and there are multiple forms of relief available to you that were not on the table before. Now, I want to be direct with you about where things stand in 2026 because you deserve a realistic picture. Under the current administration, immigration court grant rates have fallen significantly from where they were just a couple or few years ago. ICE attorneys are now using aggressive tactics, including something called a motion to pretermit, which I cover in detail in another video in this series. The link is down in the description. And this can end your case, including at the very first court hearing, without you ever getting a chance to actually fight the case, okay? Look, it's a harder environment than it was. I will not pretend otherwise, but harder is not the same as impossible. Our firm has helped many clients reach a successful outcome in immigration court after receiving a referral notice from USCIS. Cases that looked difficult at the affirmative stage have succeeded in court because the preparation was right. The declaration was strong. The evidence was organized and solid, and the case was properly built for a courtroom. You do have a real opportunity here to win your case, and what you do with it depends almost entirely on the preparation that goes into your case before you ever walk into that courtroom. So if you received a referral notice and you want to understand your options, use the time that you have right now, okay? Your individual hearing date may not yet be set, and that window before a date to defend your case is on the calendar is when your defense gets built. If you're ready to take the next step and get help with your asylum case, then please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so we can help you to secure your future in America through asylum. Again, I'm Brian Manning, and it's truly an honor to support you in your asylum journey.